and thank you for joining us today for L1 Visas from End to End, presented to you by Jakob Lipman of VisaWolf. Jakob Lipman has practiced immigration law for over 15 years. His practice focuses on employment-based immigration, counseling employers in complex immigration practice and policy concerns. Over the years, he has supported multinational and domestic organizations of all sizes and from every major industry. Jake has also lectured on immigration-related subjects in a variety of settings and has authored articles on corporation immigration compliance. He is an active member of the American Immigration Lawyers Association and is an expert in the area of immigration case management software. He is also fluent in Spanish. So we're going to get started today. Thank you everybody who joined us. We are really excited to be presenting this material to you today. As we get started, I just wanted to let everybody know that you will remain on mute through the duration of the broadcast. If you have a question, you can feel free to pose your question, and we will review the questions and answer them either as we're going through or at the end, just depending on how things are running. The session will be recorded, and we will have it available on our website following the presentation today. And I will also send all attendees the presentation that Jake is going to be sharing with you. So, Jake, thank you so much for joining us today and presenting this material to us.
You're welcome. I'm glad to be here. Kristen, thank you.
You're welcome.
So with that, I guess we'll get started. As mentioned, I've been doing immigration in the business area for more than 15 years. I've done a lot of L1 cases. I've done a lot of H1Bs. I've done quite a few of these, and I'm really happy to be able to share with you the information today that I've learned over the years, and maybe some trends and tricks and things that will help you in your practice, I hope. As Kristen mentioned, you may want to ask questions during the webinar. You can do that in the GoToWebinar control panel, and I may not be able to answer them during the presentation, but I will do my best afterwards to answer any questions. If it seems that I'm not able to get to those, I'll try to answer them in writing for you afterwards or contact you afterwards so that we can share information and best practices, any kinds of ideas that I can share. I'm happy to do that. So today we're going to spend hopefully the next 45 minutes or so talking about the L1 visas and the outline, introducing the topic, definitions within the area, talking about managers and executives, L1As, and then the L1Bs for specialized knowledge workers. We'll talk about blanket petitions, and then finally a little bit about the actual nuts and bolts of the process. And so I understand that right now there's about 70 people that are on the webinar. Really glad to see that. It's a great turnout. But I was curious. I wanted to make a poll because this is going to make it kind of fun and interactive, I'm hoping. I'd like to put up a poll to ask you, the audience, to rate your immigration experience in the business area. So why don't you, if you're able to do so, enter the information that you see there. Are you have no experience? Are you a beginner, intermediate, advanced, or are you feeling like you're an expert? And I'm going to share these results with you in just a few moments. So I think most of you are actually engaged in looking at this poll right now, and I think I'm just about to close this. Looks like everyone's voted. Any last stragglers here? Feel free to jump in. Oh, nice. We've got an expert or two on the line. So here are the results. Hopefully you can see that. Looks like we've got maybe one or two people without any experience at all. Welcome aboard. Hope you have fun today. And then mostly beginners, followed by some intermediate, and then a few advanced and experts. So I think this is really useful for me, engaging your kind of level of experience and what you might expect today. I am a little bit relieved, and just kidding, you know, because I can speak to people who I think will learn a little bit, and that makes me feel good. So let's jump in and start talking about things. First of all, I prepared a slide to contrast the H1B with the L1. And I did this because right now with the H1B cap that's coming up, a lot of times we're talking about H1s and whatever could be possible to, in lieu of an H1B, if we can't get one, what do we do? And why an L1 can be a great tool to use instead of an H1B. Number one, H1Bs have an annual quota, the L1s do not, so that you can get it all year round. That's a really key difference. Another one could be the prevailing wage. With an H1B, the employer is required to pay a wage that is average for the industry and the location where the person is going to work and the type of job being done. And so L1s do not carry the prevailing wage requirement. Could be a little bit handy in certain situations. With an L1, a bachelor's degree may not always be required or the equivalent, but for an H1B, it is. Another difference that I think comes up as a positive, usually in a negative context with the L1, is the 5- and 7-year limit. So we'll talk about this a little bit more later, but L1 visas have a 5-year limit for the L1B and a 7-year limit for the L1A. The H1B visas have a 6-year limit, but it can be extended beyond the 6 years as long as the individual has been in a green card process, and that comes up regularly in my practice. So we'll talk about that and what we do to manage that situation a little bit later. Another great thing about the L1 visa is that the candidates who are eligible for L1A as multinational managers or executives can use an expedited green card process. Another benefit, L2 spouses, the dependents of the L1 visa holder, the spouse only, is allowed to work in the United States. That's a key benefit. And then finally, there's something called a blanket petition available for the L1 visa that the H1B does not enjoy, and we're going to go into that a little bit later as well. So hopefully this will be something very useful to you. Another question I just want to ask, why did you decide to join this webinar today? Throwing it out there, if you don't mind answering, just entertain me, humor me a little bit here, so that I, again, understand a little bit better how to address the audience and the things that will be most useful to you. Whoever's answering that you just love immigration, I'm with you. That's just what I want to do all day long. All right. So thanks for humoring me with these things. So general information is kind of the, looks like it's the thing that most people are interested in. Just getting kind of a survey of the subject, and perfect. My discussion should be able to directly speak to those general principles. But I'm hoping that for the 37% that want to learn some special tricks or tips, I'm going to have some ideas for you there too. So let's talk about an introduction. What is an L1 visa? It's an intra-company transferee, all right? And the definition found in the federal regulations is an alien who, within the preceding 3 years, has been employed abroad for 1 continuous year by a qualifying organization, may be admitted temporarily to the United States to be employed by a parent, branch, affiliate, or subsidiary of that employer in a managerial or executive capacity or in a position requiring specialized knowledge. So what we're going to do during the next little bit is to break down the elements. Employed for 1 continuous year, within the last 3 years, by a qualifying organization. We're going to talk about then what makes a manager or executive and what makes specialized knowledge, and some ideas on how you can present that. So on the 1 continuous year issue, within the last 3 years, it needs to be a full 365 days. So often what happens when somebody is trying to get an L1 visa, they need to show they've been employed abroad by the related or the affiliated employer for a full year, and sometimes they've been coming into the United States as for extended visits or maybe on some other kind of visa category. That can create problems because the employment abroad is supposed to be for a full 365 days. So keep that in mind. It's a red flag you need to be looking for to satisfy the 1-year continuous employment abroad requirement. Okay, must be outside the United States. And so again, typically the time spent inside the U.S. will not count towards the 1 year. That has been overlooked, or I see most of the time immigration will not care if somebody made a casual visit to the U.S. But if it's extended, that's when you're going to possibly run into problems. Again, they may miss it, they may overlook it, but don't count on that. I would advise my clients to make sure that they had a full 365 days outside the U.S. before attempting to file for the L1. Okay, and they have to have obtained the full year before the time you actually file it, so be careful of that. Finally, within the last 3 years is when this person needs to be coming to the U.S. as the L1 transferee. So that means they don't actually need to be a current employee of that petitioner. So that could happen sometime within 3 years from the time that they did work for the petitioner. And so another thing that sometimes happens is the individuals will come to the U.S. on an H-1B, being sent maybe as an individual contributor, some kind of position that is not a manager or maybe even specialized knowledge worker. They'll come as H-1B, and then sometimes we can see them growing into their position, becoming a manager, and if they had been a manager outside the U.S. prior to coming, we can sometimes convert them to an L1A after they've come to the U.S. as an H-1B. That's because within the last 3 years prior to coming to the U.S., they were working for the related employer in a role that was managerial or executive. I'll cover this one again in a little bit, but it's one of those things that's a nice trick. It's something you can pull out of your hat when maybe an employer wants to help somebody get a green card that otherwise might take a long, long time, or find some other benefit from the L1 visa program, like the spouse being able to work. These are things that come up, and shifting to the L1A could be a huge benefit to that employee. So now we'll talk about qualifying organizations. It's either going to be a parent, branch, affiliate, subsidiary, or maybe some kind of joint venture. There could be some other types of relationships that would qualify between the organizations. Okay, so again, going back to the basics here, because I know some people here are very, very new. An L1 is a transfer of an employee abroad to a U.S.-based employer who is a related company, a parent, branch, affiliate, subsidiary, or joint venture. So what does that mean? An affiliate is one of two subsidiaries owned and controlled by the same parent or individual, or the same group of individuals, each owning and controlling the same share or proportion of each entity. Essentially, these would be siblings, companies that are related because they have the same or common ownership. This comes up frequently, again, where maybe an individual owns a company abroad. They want to open a company in the U.S. That same individual owns both companies, and now they can send a worker from the foreign company to the U.S. company because they have that common ownership. The companies do not have to offer the same services or even similar services. It's just the ownership that is important. So in some cases, it could be abroad, the company is some kind of manufacturer, but in the U.S., it's a service-based company. So they could be totally different, just as long as the relationship is there and the individual coming meets the requirements for management or specialized knowledge. A subsidiary is an entity of which a parent owns directly or indirectly more than half of the entity and controls the entity, or owns directly or indirectly half of the entity and controls the entity, or 50-50 joint ventures. And what comes up occasionally is when, as a subsidiary, the foreign company may or may not own, or the U.S. company may or may not own the majority or even half of the related entity. When that happens, an L1 visa can still be possible. You may still have a qualifying organization if the related entity controls the other entity. So even though it may own less than 50%, it has a controlling role within the relationship. That may qualify for an L1 organization. So look for that as well. These are little tricks and ideas that you may be able to use down the road. Now, in order to document the relationship between the organizations, you normally need to provide copies of the articles of incorporation that would show common ownership of both the U.S. and the foreign entities. If that doesn't exist, or maybe there's some other kind of problem obtaining the documentation, you can submit business licenses or other information that would show the ownership, annual reports in the case of companies that have been audited or maybe have some kind of a public filing. You can use these annual reports. They normally show the subsidiaries and the percentage of ownership and control. Maybe there would be contracts or other documents that would explain the relationship. Corporate filings, again, those kind of public SEC documents that may exist. And then anything else that you can find. One of the things that we frequently use are stock ledgers, maybe purchase agreements. These will show how much stock has been issued for the company and who owns it, the percentage of ownership in many cases. So these things are really useful to document the company's ownership and the relationship to qualify it for the L1 program. Okay? So we're moving right along. This discussion, like I said, we're going to try and take about 45 minutes and hopefully have some time for questions. But we're going to kind of move along right now into the heart of the matter, which is managers and executives. I'm going to talk about specialized knowledge in another minute. So in order to qualify for an L1 visa, the candidate needs to be a manager or executive abroad and come to the U.S. to fill another role which is also managerial or executive in nature. Now when we get into trouble is trying to define this and prove that somebody is a manager. It's not always very easy. Okay? So essentially a manager will either manage and control the organization or some department of the organization. Typically they will supervise and control the work of others, okay, which could be in some kind of supervisory capacity as a manager of other managers and then other reports below that, or some kind of professional employees or other managerial employees. And in the absence of reports, sometimes the individual can be the manager of a function within the organization. A function of the organization could be some kind of role where the individual has a lot of responsibility, so maybe like a controller within the company or a director of something like a business development where they may not have individuals that they are responsible for, but they are definitely responsible for an important function of the business. And maybe they work with a lot of vendors and contractors or other types of outside entities to get the work done. These people can often qualify for an L1 visa as they are some kind of functional manager within the organization. Normally, first-line managers do not qualify unless they manage other professionals. So that means, and I'm going to show you a diagram in a minute, that essentially a situation where somebody manages a line of people maybe on a factory floor or something like that of non-professionals, that's not typically going to qualify. And we'll see that diagram in a minute. I think it helps really to explain what it means. Normally a manager or executive will have authority to hire and fire people or recommend employees for advancement. And again, they need to operate at a fairly senior level within the organization. So you're going to show that normally with something like an organizational chart. That's one of the documentary requirements that you will always want to be looking for. When you start an L1 case, typically I will ask for the employer to provide a chart that shows where the employee fits into the overall organization of the company. So not necessarily just what reports are there that would be reporting to that individual, but what's happening above that individual. Often will show the context of their responsibility, their authority within the company, what kind of responsibility they may have, and again, who they report to. If they're reporting directly to CEO or something like that, it's different than if they report to a lower level manager within the company. So those organizational charts are going to play a very important role in your ability to prove what kind of person you're dealing with here and whether they really appear to be management material. The same thing is true when you're sending them to the U.S. You need to show where they will fit into the U.S. organization and provide that organizational chart that will express the level of responsibility for this person, what they're going to be doing, and the titles and functions of people that they will oversee. Or again, if they don't oversee people, where they fit into the structure, and show that that's a very responsible and important role or a function that they manage. So it will be obvious to the person reviewing at immigration that this is an individual who operates at a high level. One other thing to consider there are factors like salary. Okay, if you're not going to offer this person, if the company's not offering a high salary, it may indicate that they're not really a high-level manager or executive. So I've seen many times that's going to be a huge red flag for immigration if you're trying to establish somebody as a manager or executive and they're coming to the U.S. to be paid, $40,000 or $50,000, maybe even questionable in some cases, because a manager or executive of multinational companies probably is going to be making more than that. Not always, but if you don't show a high level of income, you're going to have to show a lot of other factors to establish the responsibility of that person. Again, a person who is a manager or executive is going to have discretion over the day-to-day operations of their function or activity. What does that mean? That they don't have people telling them what to do all over the place, and that they get to essentially manage themselves and their reports and have that latitude day-to-day without somebody hovering. And these are things that separate kind of normal staff and lower-level managers to those who operate at the higher levels. So to show you kind of what it means visually, on the left you're going to see that in one case you've got the individual manager at the top who would be the candidate for the L1 having another type of manager below with at least some reports below that. So an L1 manager will often have some other supervisory personnel below them who would have reports below that. So at least a three-tier structure that would show they have that responsibility over other managers. Now, of course, this is kind of a minimalist view of what it could be. I wouldn't recommend having an organizational structure any, much less than this, unless these are, again, high-level employees. But at the very minimum, you would have your individual managing someone who manages other people. Likewise, over on the right, this could be the type of line manager that would satisfy the requirement, where you have your candidate who manages several other individuals on a horizontal line. So again, there's no depth or hierarchy of management there other than your candidate managing a line of other people. As long as they're professional workers, it's going to be okay. And what are professional workers? Well, a professional for immigration purposes is normally somebody who holds at least a bachelor's degree in the area of their special occupation that they perform. So a typical one that I see all the time would be engineers, software engineers, systems analysts, people like that, that normally have a bachelor's degree within a tech field or some other kind of related field. So that would be a situation where you can satisfy the requirement and still only have a single layer of management there and not the multiple tiered hierarchy as you see on the left. Okay, so we're going to kind of come back again. We're going to talk about executives. So we talked about managers, and now we're talking about executives. These are even higher level employees, right? These are people who operate at the higher levels, at the C level, vice president, maybe director. They have a lot of responsibility, especially in bigger organizations. They are responsible for establishing goals and policies of the organization. If they manage a function, they basically are responsible for that entire function. I'm thinking of like a treasurer within the company, something like that. They have wide latitude and discretion to decide what they want to do every day. All right, and they only get general supervision. Maybe they answer to people like board of directors or stockholders. Okay, they don't have maybe a boss hovering, but they do answer in many cases to outside investors and things like that, which is a big job by itself. As I've seen in some of the companies that we've worked with, these people have quite a bit of responsibility to the board or to stockholders in many cases. And so it's not that they aren't managed, it's not that they don't have anybody that they really have to answer to, that they're accountable to, but they are operating at the highest levels of that organization. Very good. So, specific issues that relate to the managers and executives. I'm going to repeat a few things that we talked about earlier, just kind of, make sure that you understand it and that you walk away with something that you remember here. One is that with manager executive L1A, there is a 7-year limit to the time that a person can spend in the country. That can be restarted, or you can reboot, I guess, after 1 year of that person leaving the U.S., coming back after 1 year abroad, a full year again. Okay, so that could be, they could bring it back. However, by the time 7 years roll around, you probably want to have some other kind of plan in place if you want that individual to stay, and that would be the green card process. So a huge benefit of L1A manager executive is that there's a streamlined green card process or permanent residency for that individual. They don't have to go through labor certification, which is a test of the labor market that the U.S. Department of Labor requires for most other kinds of positions. In the case of a manager or executive, they do not have to prove to the Department of Labor that there is no other worker in the U.S. who is able or willing to do this job, because this is a very specific kind of high-level functioning position within their company. It's not something that you're going to walk outside and find some U.S. worker who's necessarily just ready and available to function at a high level within the company and take on the role of somebody who's been a high-level manager outside the U.S. coming into the U.S. office. And so they don't require that initial step of labor certification. Saves a lot of time, saves a lot of money. Another giant benefit of the L1A program is that when you do the green card process, it comes under the EB1 category for the green card. It's a category of preferences that the Immigration Service has where visas are available by preference. This is first preference, so it goes along with other people of outstanding ability, maybe outstanding researchers, people who are really noteworthy and have great accomplishments. These people do not usually have any kind of a waiting list where they can apply for the residency immediately upon filing for the green card itself. Whereas people in the EB2, the second preference, or EB3, they in many cases, especially if they're from India, there's an enormous waiting list for them to obtain their final application for residency. It can take a decade. It can take multiple years, and even possibly longer. We have yet to see how long these people are going to wait in the backlogs that exist. So if there's any way to qualify them for the EB1 through this manager or executive opportunity, it's a very big deal. And as I was mentioning earlier, one of the ways that we do that is you look to see if a company has sent a worker to the U.S. under H-1B program. It's very good to look back and ask whether they held some kind of manager position abroad before coming to the U.S. under the H-1B program. Many times somebody will be sent to the U.S. as an individual contributor without some specific managerial role, but that will develop and change over time. So maybe a few years later after they arrive, they are now managing a team. If that's the case, and they had managed a team outside the U.S. prior to coming, then you may be able to change their status to L1A, and now they will qualify for streamlined green card processing. Okay? It's a really excellent option to consider when that is available. All right, so shifting gears, specialized knowledge. So there's two categories of specialized knowledge that can be approved for L1B visas. L1A, executive managers, L1B, specialized knowledge. Okay? Specialized knowledge of the knowledge that you're looking for is of the organization's product, service, some kind of research, maybe equipment or techniques, management systems or other interests, and how these things apply within the international markets. Okay? So these are often proprietary kinds of details or information that that employee would have working abroad. They learn about the company, they understand the equipment or maybe some kind of process, the products, the techniques used by the company, maybe the strategy of the company, and they bring that knowledge to the U.S. to be applied here. Okay? The other thing that they might have is some kind of advanced level of knowledge or expertise in the company's process or procedures. So advanced level may not necessarily be specialized knowledge, but it's advanced, okay? And the distinction between those things is obviously kind of fuzzy and open to interpretation, but we'll talk a little bit more about how we prove these things and what it means in the next little bit. That brings me to another poll that I want to bring to you, okay? L1B visas have been the subject of a lot of controversy because the U.S. Immigration Service, as nice as this visa sounds, they just don't like to issue the visa. They don't like to approve them. They have a very greedy concept for what it means to have specialized knowledge. That's my experience. And I wanted to see if, in fact, that would be your experience as well. So let me put up a poll here. When filing an L1B case, how often do you find that an RFE is issued? Is it never, seldom, occasionally, normally, like regularly, or always? Okay? I work with a lot of smaller and mid-sized companies. I work with a few bigger companies. I can tell you in my experience there's a difference. Okay? If you work with a lot of bigger companies, name brand companies, probably your experience is going to be very different than the practitioner that works with the smaller companies. Smaller companies tend to get a lot more of these requests for evidence. I'm going to close that poll and I'm going to share the results. You can see that at least a very small percentage find that L1B visas rarely get RFEs. Okay? I think the majority of us who practice in this area will find that there is probably at least occasionally or normally, and in fact here probably at least 50% feel that it is a regular or almost a kind of an obligatory thing that you're going to see an RFE when you file for this category of visa. It just happens. And often it's a boilerplate type of RFE that will come where it asks a million things about the specialized knowledge, about the companies, and it's very frustrating for your employer. It's very frustrating for the individual who feels that they have specialized knowledge. And I think it's wise for you to set that expectation early in the process when you're talking to your employer clients or even the individuals, that they understand that the U.S. Immigration Service has a very, I want to say conservative, but that word doesn't mean the same thing to everybody. Maybe they have a narrow view of what this means, and they have yet to really define it. They did issue some guidelines earlier this year in March. This is another thing I was hoping maybe I could poll you about. In your experience, do you see changes or positive changes since the USCIS issued their new L1B guidelines in March of this year? So I'm interested in what your experience is. I know what my experience is. And I'd be curious for those who are saying that, yes, there's been a positive result, I'm interested in what that means. I'm just going to close that poll and kind of share it with you. So again, I feel like the majority of you feel that there hasn't really been much of a change. That's my perception. But if there is anything positive, it feels like maybe the Immigration Service has at least acknowledged that there is a problem there, that they needed to issue the guidelines. The President did ask them to produce some kind of guidelines when he was looking to reform immigration overall, because employers have complained about this. The immigration bar has complained quite a bit about this, that there are no real specific guidelines and that the RFEs continue to come. And even after this issuance of guidelines, I see that the RFEs continue. However, it is a sign that maybe there's a sense of their, nodding to the accountability factor, that they are at least being instructed from the highest levels of USCIS that they are supposed to favor employers and look for specialized knowledge where in areas where I think that in the past that they were probably reluctant to do so. It seems like this hasn't really taken off within the organization as of yet. People are still, I think the adjudicators are still operating as usual, but hopefully we may see some positive changes going forward. So let's pick apart a little bit more specialized knowledge. This is knowledge in many cases that would not be generally available inside the U.S. Okay, these are different things that you can point to when you're trying to explain what specialized knowledge means in your support letters and documentation that will accompany the L1B petition. So one of those is this knowledge that the individual brings is not generally available in the market here within the U.S. or maybe even within the organization that is petitioning that person, that there are no other workers or there are limited numbers of workers that would be holding this kind of knowledge. Another one that you can use that's helpful is to show that that individual or that beneficiary's knowledge makes the petitioning company more competitive, and how that knowledge will be applied to advance the company's interest to make it more competitive either worldwide or in the U.S. market. Okay, so likewise, you show that this individual is going to be assigned to work that has had a positive impact on the petitioner's image or their financial position, so it's had some kind of benefit. This is maybe some kind of state-of-the-art type of knowledge, or something kind of sexy and new and interesting that's coming up, maybe something kind of trendy, and that's why you're bringing the person, because they're going to enhance the company's reputation and build that, maybe that trend out within the U.S. market, or expand somehow what's already been happening with that individual outside the U.S. Okay, and in many instances, and I think in the past, you really kind of had to show that the knowledge this person held was somehow proprietary to the company. The memo that was published in March, it said that the knowledge doesn't necessarily have to be proprietary. It could just be that kind of advanced knowledge about the company or something else, maybe even something that could be available outside the company. But I would say if it's not something specialized and proprietary, it's going to be a lot harder to show how this is really novel and different, and how the person's knowledge is special if it's not something that is proprietary. You would probably have to show that it's only information that's narrowly held by a few others and maybe within a small industry, as opposed to just your client's company. Another hot button issue that's come up in the past is that L1B workers used to have a pretty hard time working for third parties, meaning like contracting companies sending L1B workers out. And this is because if you say that they have specialized knowledge and they're going to work at a client site, which specialized knowledge are they using? Specialized knowledge that's related to the petitioning company, that brought this person, or is it some kind of specialized knowledge about the client's company and their products and services? This is when you run into trouble, and so you've got to be very careful. You want to read that memo. You want to understand what the guidelines are at this point in time, but essentially you're going to have to show that that assignment to the third-party location is going to require that specialized knowledge that this individual obtained outside the U.S. and bring it to the U.S., apply it to that project. Contracts are going to be helpful. The documentation that you want to show would be like patents and licenses, trademarks, to show there's proprietary information. Those are often very useful. Other kinds of contracts that may exist, again with the third parties, to show who's in control, that there will be management of the contracting worker at the client site by the petitioning entity. Okay, so the petitioning employer will continue to manage directly and supervise the work of that individual, even though they may be sitting at a third-party site. You've got to establish that and show it with documentation. It's probably helpful if that's written directly into the contracts and the charts and organizational charts that will be provided. If you can show there are proprietary processes or methodologies used within the company that this person has been exposed to, that they've worked with, that's going to be useful. Certifications and trainings that they may have had within the company or on certain kinds of technologies that are used in the project or the process that they're going to be supporting in the U.S. Often there could be some kind of corporate strategy that the person has been exposed to. I think of marketing or other kinds of strategic employees at the higher levels. They understand the company's overall goals and kind of their plans, and so you can talk about that. And then trade secrets, secret sauce, the things that these people are maybe have been again exposed to within the organization that are secret and that cannot be shared outside the organization. The recipe to a certain kind of a soda pop or something like that comes to mind. So these are things that you might use to document your specialized knowledge. So let's talk generally about the L1B. There's a 5-year limit. Only 5 years, and because of how long it takes to get a green card these days, you may want to consider changing somebody in this kind of category to an H1B at some point. Okay? Reason is, H1B, like I mentioned earlier, it normally has a 6-year limit, but if the person is in a green card process, it can be extended for multiple years after the 6-year limit. The L1B visa cannot. And so if you can convert them or change status to H1B, you can now position this person or your L1B holder into a long-term position in the U.S., a long-term situation where the employer can continue to keep them here. These people will be normally subject to the regular EB2 or EB3 green card process that I talked about earlier, where they have to go through labor certification, which adds to the time. It adds to the waiting list that they will sit on while they await their green card. For everybody except China and India, the wait isn't really so bad right now, even for the EB3, the third preference category. It's pretty good, actually. But traditionally, that can fluctuate, and so it's preferable to be in the EB2, which requires master's degree, or bachelor's plus 5. We can talk about that maybe on another webinar. Prevailing wage applies to these workers in the green card context. So if you're bringing somebody from L1B, you got to look at their wage and make sure that they're going to meet the prevailing wage requirements, which is a minimum wage that Department of Labor will require to process their green card. Okay. And again, in some cases, the company has sent a worker under L1B program to be an individual contributor. Maybe along the way, as they have worked in the U.S., they develop their role, they become managers, and now you might consider shifting them to L1A so that they can enjoy those benefits that we have already talked about. Okay, keep that in mind. Now, I want to talk briefly about a blanket petition. Okay, a blanket petition is something that you get approved for your client that will allow them a faster process to obtain the L1 visa. certain companies qualify. I'll talk about which companies are going to qualify here in a minute. They can apply directly to the U.S. consulate for the visa, where normally you have to apply initially to USCIS for individual L1 petitions. It saves a huge amount of time, and you also avoid the USCIS prejudice against the L1 visa program. You don't need premium processing because the consulates are generally very fast to review and approve these cases. So the other benefit is your client gets to apply directly to the U.S. consulate, and I have found in my practice that the U.S. consulate seem to be quite a bit more friendly towards L1 visas than USCIS is. Your employee client will have a face-to-face interview with the consulate, and that can be a really positive thing. In some cases, it could be a negative if that individual is not really articulate on the issues surrounding their visa and their application. That person should be totally instructed on how to describe what is specialized knowledge if they're an L1B applicant, or if they're going to some third-party assignment, they need to be able to articulate that they will be managed by the petitioner, that they may be going to another location, but again, that they will apply their specialized knowledge there and be managed by their own company. And these are requirements that your blanket applicant should be looking at. Who can get a blanket? Well, it needs to be a company that's been in business at least 1 year, must have at least 3 offices, and at least one of the following: 25 million in combined U.S. sales, a workforce of at least 1,000, or at least 12 L1 approvals within the last 12 months. My practice, my experience has told me that usually the employer that has 25 million in combined sales that's going to be the one that helps them meet the requirement. Okay, the first approval that you get is valid for up to 3 years, and then the second approval will be valid indefinitely. A little note of caution: that first approval, if you don't renew it and you forget and it expires for any reason, you can't apply for another blanket for 3 more years. So don't miss that. Don't be the guy that misses that deadline. Always renew that blanket petition. Put it on a calendar. Don't miss that one. It would be a big mistake. So let's talk quickly about process. For an individual petition file with USCIS, you find the location of the work and check the USCIS website. You might want to check it every single time that you do one of these, because often the location where you're going to file it is going to change. They do that without notice. Well, they may give notice, but you won't see it all the time. And also the states where the different service centers will process, they tend to stay the same, but you might want to just check, because the state where you happen to have this employee working, you may accidentally file in California or Vermont, one or the other, and you may end up making a mistake there, wasting time. Then the fees: $325 is the base fee with a $500 anti-fraud fee. Anti-fraud fee is actually paying for USCIS workers to go out and contractors to go out to check the status of these L1 employees to make sure that they're actually doing what was described in the petition. So make sure and warn your employer clients and even the individual that if there are changes to the work conditions, the location, or anything else, let you know as the attorney, because you need to notify immigration of changes to their locations and other kinds of, maybe their title has changed or other things. This needs to be informed to immigration so that if they do send out one of their workers to see who's doing what, that your employee, you've notified the immigration with an amended petition or something to alert them that there's been a change. To get the premium processing, I'd say the normal L1 these days is taking 2 to 3 months. With premium processing, it's 2 to 4 weeks if you get an RFE, less than 2 weeks if you don't. Okay. The blanket petitions, those are filed with the U.S. consulate. Every time you file one of these, I recommend you check the consulate website to see what the instructions are for filing a blanket petition. They do change once in a while. Each consulate may have some specific instructions. You file it on form I-129S, usually in some kind of triplicate form, means like 3 copies, original copies. And then also the form DS-160 is filled out online normally with the U.S. consulate when you schedule the appointment for the interview. The fees, $160 is the non-immigrant visa application fee. Sometimes there are additional fees depending on the country. They have some reciprocity tables that will tell you what the additional fee could be depending on the country. You can look that up in the State Department website in the Foreign Affairs Manual. A $500 anti-fraud fee is there as well because these people may be investigated, and the Immigration Service will go out and pay them a visit occasionally. As I mentioned before, that's something to keep in mind as you prepare people for what can happen in the post-approval process when the employee is finally admitted happily to the U.S. to go work and fulfill their assignment. Make sure they know that they need to keep you aware of any changes to the employment and the conditions that exist. So that pretty much wraps up what we came here to talk about today. I think I may have gone over about 5 minutes, my 45-minute estimate from the very beginning, but I thank you for your attention. I enjoyed giving this presentation. I always enjoy this kind of experience. I enjoy the colleagues that I have and the people that I work with in my office. I just really like what we do here. It's a great practice. I noticed that there may be some questions, and I'm going to try and bring those up here and see if that will allow me to do that. I'm trying to see if maybe, Christen, can you help me see those right now? I'm not seeing the questions. Okay.
I see a little question mark on the control panel. If you do not, I will open it and I can read the questions and then you can answer them.
Okay, yeah, I don't see it. So if you don't mind, that would be great.
Sure. Okay. So the first question we got before we even got started, and the question is, if client gets L1 status by COS in the U.S., is it correct that he must give L1A visa from consulate overseas in order to re-enter the U.S. once he goes back to his original country for business trips?
So COS means change of status, okay? So if a person is in the U.S. under some kind of H-1B, maybe a B-1, a visitor visa, you can do the change of status and convert them to an L1 visa in some cases. That means they don't have to leave the U.S. prior to becoming an L1A or B and work here in the country. So it's a very helpful tool, change of status, and we use it occasionally for these kinds of cases. The question, I think, is that when that person leaves the U.S., what's going to happen before they can come back? Well, if they've never had an L1 visa before, they're going to need to apply for the L1 visa at the U.S. consulate prior to returning from their trip outside the U.S. So they will not be able to come back as an L1 visa holder unless, once they've left, they visit the U.S. consulate, get their visa, and come back to the United States. So the answer is yes, they must visit the U.S. consulate prior to returning.
Okay. Thank you. And I'll read the next one, but just an FYI, Jake, I took a screenshot and emailed it to you so you could actually see these questions that I'm reading.
Thanks.
You're welcome. Number 2, can the owner of a foreign company with 2 executives send themselves to open a new affiliate in the U.S.?
The answer there is, I'm going to say theoretically, yes. Okay. In a small organization with only 2 employees, you're going to have a hard time there showing that this person is coming in a managerial or executive role with such a small organization. Immigration doesn't think that somebody in such a small organization is operating completely at an executive or managerial level. They assume that in that kind of a really small, tight unit, that the individuals will be doing all kinds of non-managerial work like administrative tasks because they don't have a support staff standing around helping them do things. And so some portion of their work, maybe a significant portion, will be doing things like answering the phones or scheduling meetings or just doing the things that other people do in other bigger organizations. So be aware of that. In describing the work of those individuals in the foreign company, the company operating outside the U.S., be aware that you need to explain how these administrative or kind of perfunctory functions are going to be handled. Are they being done by these individuals? So if you can show that there's only 2 people in the organization, again, I think it's going to be hard to show that these people are really operating at that managerial or executive level. It may be possible, though. I would suggest building a little more infrastructure around those people, maybe a layer or 2 of management prior to trying to qualify them for L1 visa. The other thing to consider is that it is generally easier to get a first-time L1B for a startup company. The U.S. Immigration Service will allow the company to send a worker to do the startup. They typically give a 1-year visa. And during that year, the company will have to execute a business plan showing that they're going to be up and running within the first year. By the 3rd year, they should have a company infrastructure that will support several employees and a management situation. Even at the end of the 1st year, there should be layers of management there. And again, an ability to show that all of the administrative functions and the things that are normally done by mid-level and lower-level employees are going to be handled by other people at that point. So when they go to renew the visa, there needs to be, after the 1 year, there needs to be some kind of structure there that's going to show that they really are operating as managers or executives. The last thing I want to mention is that in that situation, if there's only 2 employees and they're trying to come and establish themselves in the U.S., immigration is not going to allow it if they see that the foreign company is basically packing up shop and going away. So in that case, there will not be related employers there in order to qualify the relationship between the companies, because one is going to disappear when all the workers come over to the U.S. So you have to show that there will be an existing business back in the home country, that it continues to operate, and that it will continue to do so throughout the entire life of this L1 visa. So it doesn't disappear after a year or 2. Each time you renew the visa, there will have to be a showing that the old company continues to be there. So, long answer, sorry.
That's okay. And we do only have 2 minutes, Jake, that are remaining. So I was thinking, do you want me to ask another question, or would you like to respond to the remaining questions to each individual via email?
Go ahead and ask one more, and let's just see what we can do, and then we'll wrap it up if that's okay.
Okay, sure. We had a quick question about getting a copy of the presentation. I can answer that quickly. We are going to be emailing out this presentation to you as soon as we're finished. And then another question for you, Jake, would be, what are your recommendations for people who are traveling on a blanket where the consulate hasn't stamped the I-129S and the visa is issued for 5 years?
So I've seen a lot of issues come up around this. When the individual comes into the U.S., the visa stamp will normally be, or in some cases will be valid for a long period of time. When they enter the country, the petition validity date for the blanket is printed on the visa stamp as well. So sometimes the individual will only get an L1 extension through the period of the blanket validity. All these kinds of confusions come up. I don't think that the admitting officer at the customs really knows what to do with that all the time. So if the individual knows and is prepared when they come in, they should get at least a 2-year increment when they come in on the L1 blanket. If they don't get a 2-year increment each time they come, then it may be worth, of course, telling the attorney so the attorney can figure out what went wrong, if anything. Sometimes it corresponds to the validity of the passport or other things that they may be able to remedy. But there's an office called Deferred Inspection that the CBP operates, and normally they have them in population centers. Most of the big cities have one. And you can instruct your client to go to that office. If there is a mistake on the I-94, I don't say, well, shouldn't say mistake, but the admitting officer indicated some period of time less than what it should be, you can often send them to this office for deferred inspection. And the folks there review it and they say, yes, the attorney's right, we should have given you 2 years, here you go. And it's a happy ending for everybody. And they didn't have to travel outside the U.S. and things work out pretty well. So consider that as a, you know, again, one of those tricks up your sleeve to save the day when you come in to solve these kinds of problems.
Okay.
So I think that's it. Yeah. Hey, I just want to say thanks, Kristen, and everybody else for the opportunity to do this. It's been fun. Thank you.
Yes, and we do have your questions, and we will respond to them via email. Thank you, everybody, so much for joining. We really appreciate you taking the time to join us today.